Good afternoon, and may it please the court. This case boils down to a single issue: whether or not a jury could find that Mr. Favela has satisfied the exhaustion requirement under the PLRA. At its heart, the issue is evidentiary. Could a reasonable fact finder use Mr. Favela's testimony and the evidence available to find that he did, in fact, file a grievance and appeal, despite the fact that the prison claims not to have those records? Mr. Favela's answer to that is a simple yes, but it's worth considering this issue from two distinct angles to show why yes is the only possible answer that this court can reach. First is through the lens of policy. In our respective briefs, the parties have framed the issue in terms of risk of abuse. Appellant argues that requiring prisoners to find or to show that prison records specifically are the only way to satisfy the exhaustion requirement risks abuse by prisons not having a robust enough record-keeping system that would then deny their ability to vindicate their rights. Appellees argue that allowing evidence such as what Mr. Favela has, a sworn statement, risks abuse in the form of frivolous lawsuits by prisoners attempting to skirt the PLRA. In short, the first risk has greater consequences and no deterrence, but the second risk has multiple deterrence, disincentives, but the only risk is a slight uptick in prisoner litigation. The second lens through which we should look at this case is through that of logical reasoning. As appellant will demonstrate, finding in appellee's favor requires making four errors in terms of just baseline reasoning. First is ignoring basically the epistemological root of how facts are found in the judicial system. The second is committing at least one formal fallacy. The third is committing at least one informal fallacy. And the fourth is ignoring the directive of the PLRA as it's expressed in terms of a logical syllogism. So turning to that first point about policy.
Before we go down all that epistemology, doesn't this case just reduce to a legal question, not a logical one, and not a policy one? Was the sworn declaration, is that sworn declaration conclusory or not?
Your Honor,
why isn't that the issue before us? So
the issue is the singular issue about the sworn declaration.
Okay.
The question is not whether or not it's conclusory. The question is whether or not it's sufficient summary judgment evidence, along with what else has been provided to the court below in this court, for a reasonable fact finder to agree that Mr. Favela has met the exhaustion requirement.
He says he did, and he swore to it.
Exactly.
And yet you would agree that what he says about the first step is a little more detailed than what he says about the appeal, correct?
Yes, Your Honor.
So does your argument depend on the specificity given as to the first step, grievance, carrying over to make up for what might be seen as a conclusory remark about, oh, I timely appealed it?
I would not agree with that, Your Honor.
Okay. So do you have a best case that a sworn declaration stating, as he did, relatively minimally, that I did appeal it, they're just committing misconduct because they destroyed it, they don't want this lawsuit to happen?
Your Honor, the best case I have is Dillon versus Rogers, which basically stands for the proposition that this question is both a question of law and of fact. So it doesn't have to do with the sworn statements in particular. However, it establishes the fact that the factual issues in this case are indeed strictly in the realm of facts. And facts, of course, need to be found by fact finders and not determined.
So you're saying it's just a credibility issue. He said he did it, he swore to it, he gave some detail, and that's enough, and other circuits have said so. Is that correct?
That's correct. In addition to the fact that we have other evidence, we have other correctly completed, timely grievances, appeals throughout his time in prison, and specifically with respect to the events at issue. So why is it that this particular grievance and appeal are mysteriously absent from this case? It's all of this evidence that lends credibility, that a fact finder could find lends credibility to this sworn statement and potentially testimony. And in addition to the fact that defendants have not directly impeached that statement, apart from pointing to the prison records themselves and saying, hey, there's this grievance and appeal aren't there. We agree that the grievance and appeal aren't there, but that's the exact issue that we're getting at, is that from an evidentiary perspective, there has to be a second way. There has to be a way other than just the prison records to establish that an inmate has met the exhaustion requirement of the PLRA. Which is where,
You're worried about prisons being corrupt, essentially. Corrupt or incompetent or whatnot.
Not necessarily corrupt, Your Honor. Although that can be the case, it can also be the
But it
case.
could be incompetence.
Yeah, it can be simple incompetence, exactly.
I mean, they just lose it.
Yeah, exactly.
Right. So, yeah, exactly. So I take that point. What is the evidence? Is there evidence of exhaustion at the second step other than the declaration?
Not that's on the record, Your Honor.
Okay, so all we have on the summary judgment record is this paragraph 10 of the declaration.
Right, but that has to be understood in context of this other evidence that we have of other correctly completed grievances and appeals, including about this case and the fact that some of those other...
So what do you mean by that? That he's successfully done a lot of these grievances in the past? Is that...
Exactly. It lends credibility to the fact that if
he knows how to do this.
That he knows how to do it. He would have done it correctly, and the fact that one of the other grievances has to do with the integrity of different officers handling the evidence of this particular instance.
And I understand where you're coming from, all that. I guess, though, at the end of the day, this paragraph, this one sentence, seems to read in a sort of a just stating the conclusions without giving us any factual detail.
Your Honor, I understand how you could read it that way. However,
I mean, it literally says, I filed in a timely manner.
Right, but there's no other formulation of that. There's no other
You could
be alleged that would be...
No, I get that. I think it's fair for you to ask, if this is not enough, then what would it take?
Exactly.
But you have, what would it take would be what's earlier in that paragraph, right? At step one, within 5 days I filed. I admit that's not the most, robust addition, but it's only a few words, but maybe those few words are necessary. We don't have any sense of timing. We don't really have any sense of anything other than clients say so that I met the legal requirement.
Other than the timing that's implied by the grievance procedure itself. I mean, in order to state that an appeal was timely filed, you know what the time is between the ruling on the grievance and the appeal, and that it was done within that time. I mean, stating it in that way, it doesn't add any more context than what was already provided, and I would argue it doesn't add that much more context.
Yeah, no, look, I sort of see this as a vexing case, because I think one side can say, well, look, just if you say it's timely, then tell us it was X number of days, and then you're going to respond like, what do you care? It's not all that important. It's vexing.
Right.
Is that your essential take? Is sure, we could have told you instead of timely, we could have told you it was day 6, but who cares? Is that sort of your point?
Not exactly who cares, but the general thrust of that, yes. It's not so much who cares, but how would that have been communicated? How would an inmate know that? There's.
Are you saying this wasn't a counsel
declaration? This is kind of a nebulous.
What? Are you saying this wasn't a counsel declaration? Pardon me for getting how this went below.
No, of course.
This is counseled, right?
That's correct. But I mean, it's not a requirement. It's not something that has been established in the past. Of there has to be a certain level of specificity about that sort of thing.
I would think you'd be saying this declaration has a lot of specificity.
And
It says he needed medical care, he didn't get it. It says he needed to be moved, he didn't get it. It says he gets attacked, then he grieves, he says exactly when he did, 5 days later. And then it says, I timely appealed, but it also then says they're trying to frustrate a lawsuit.
right. So
Where
if we're boiling down to the statement of I timely appealed, whether or not that's conclusory, I mean, I don't think that there's like we discussed earlier, a way to state that in a way that wouldn't be conclusory.
What if a plaintiff said, I timely did X and I timely did Y? That's it. There's no dates or anything. I
mean, I think that this has to then get to, a case-by-case sort of situation where, if that's all there is and there's no other evidence and that's just in a vacuum, then probably not. But like Judge Higginson was just getting at, while you can boil down to that particular statement, there is a lot more context, not just in the declaration, like Judge Higginson was just talking about, but also in the rest of the record.
Well, if he just said, I timely did both, and he doesn't swear under pain of perjury, you're beginning to get closer to Kip, aren't you? Or Kid.
Right.
Which one is it? Kid.
K-I-D-D.
Yeah, Kid. But
Right. And
there the guy just had the unprocessed form. It's looking pretty skeptical. But here, the prisoner's saying, you can prosecute me for perjury if I'm lying.
exactly, and that's one important. The second important distinction you started to get at was that he had the unfiled form. Which, if he had the unfiled form, what form did the prison have at that point? What we're saying is that we filed the forms, the prison has it. They just claim that it's not in the record at this point, and then it becomes a credibility issue, not just of jury. Do you believe that Mr. Favela did in fact timely file this grievance and appeal? But compare that to not just, hey, it wasn't in the records, which is all defendants have pointed to this point, but also, you would expect that to impeach that kind of statement, to impeach that kind of testimony, that they would have to point to something like the rigorousness or the integrity of the procedure itself, of the record-keeping procedures themselves, to say that in order for this not to be there, it has to be that it wasn't filed. But that has never happened.
These PLRA exhaustion cases are occurring all over.
Right.
We affirm the summary judgment order. Are we creating a split with any of the other circuits?
Not to my knowledge, Your Honor.
If we affirm, if you lose, this declaration isn't sufficient, would that be inconsistent with what other circuits are saying? If
Your Honor,
you lose.
Right. Your Honor, I think that would require a little bit more depth of research in order to answer that with a level of confidence that I'm not prepared to give you at this particular moment. I don't know that there's a specific case that says in no uncertain terms.
I'm not trying to hide the ball. I looked to me when I looked at the Third Circuit case, that had less evidence of exhaustion.
Right.
You remember the Palladino case?
Yes, I do.
So if we were to say this doesn't count, a sworn statement by a prisoner with this level of detail, that they filed it, and the prison responds, you're out of luck, you can't sue because we can't find it. Would that create a split with how the Third Circuit is looking at this situation?
Right. And I do apologize. I understood your question to be, a broader consensus of the circuits, but in terms of specifically
Well,
the
no,
Third
I'd
Circuit-
love to hear cases that you think are against you also. What circuit would you definitely lose in? Because
No,
you've
and-
already decided a sworn declaration from a prisoner doesn't even create a fact issue. Is there any circuit that said that?
Not that I'm aware of, but I was just kind of coloring my response.
Okay, go on with your argument.
Of that, but yes, this would split with specifically the Third Circuit, and that's what I'm prepared to.
What was the language in the Third Circuit?
Pardon?
What was the declaration language in the Third Circuit? If you say there's a split, that suggests that the record in the Third Circuit was the same.
Right.
I'm not hearing you say that.
Right, and I don't have the Third Circuit language in front of me.
The Third Circuit's opinion talks about how there were specific facts.
Right. Apologies, Your Honor. I'm just trying to collect my thoughts here. So the Third Circuit opinion, yes, says there were specific facts, but that there were fewer specific facts than were present here. Here, if like we were doing earlier, looking.
You talking about Palladino?
Yes.
Wasn't there deposition testimony though in Palladino to support the claim of exhaustion? Wasn't there deposition testimony in Palladino?
It's still sworn testimony, so that's why we're comparing the apples to apples here. The deposition testimony is still sworn in the same way that this declaration is sworn, so there's still the penalty of perjury for both. And the level of specificity issue boils down to looking beyond just I timely filed the appeal. That's where we're looking at the entire statement itself, the entirety of what was sworn, what was submitted under penalty of perjury, in addition to the additional evidence provided for summary judgment.
I mean, what Palladino gets you is that an affidavit, if specific, can be enough. But I'm assuming Palladino here. The question is, was your declaration specific enough?
Yes.
So we're still back to our original discussion.
Yes. Thank you, Your Honors.
Thank you, counsel.
Good afternoon, and may it please the court. My name is Marlayna Ellis, and I represent defendants, appellees who are or were at one point formerly employed by the Texas Department of Criminal Justice. So although this court does have de novo review, the district court's grant of summary judgment should be affirmed for two very simple reasons. First, appellant failed to exhaust his administrative remedies. And second, in response to over 200 pages of grievance records showing that he did not file a grievance for the claims he now brings in this lawsuit, appellant produced a conclusory affidavit that was vague as to both the timing and substance of his purportedly filed grievances. So, as this court is well aware, exhaustion is mandatory under the Prison Litigation.
Was it conclusory as to both steps or just the second step?
I would say largely the second step. To your point earlier, there is some specificity regarding this 5 days or so language, but really the concern here is about the step 2 and whether that was in fact timely. And that's critical because exhaustion has to be done properly. So that means compliance with the agency's procedures and deadlines. And so it's not
Your
enough.
point is, it's got to be timely, obviously.
Yes.
And saying that it's timely is not enough. You've got to tell me it was 5 days or something like that.
Correct, because here, this is the definition.
Pretty formalistic, though, isn't it? I mean, it's not like time is difficult to, like, literally all you had to do was cross out timely and put in 3 days, and that's enough?
I think it is needed to have some level of specificity because, as I mentioned before, there are deadlines that govern the grievance procedures. So if something is timely, this court needs to be able to evaluate whether it was in fact timely. And so if there are no details about, for example, when the step 1, which arguably was provided, and then when the response was received, because remember, the TCJ grievance process allows them to respond within 40 days. And so we need some sort of information regarding when the response was received, and then the inmate has 15 days to file a grievance from the receipt of that response. So I would say that
It's formalistic, but that doesn't mean it's wrong. It's
correct, correct. And if it's such a small burden, why not provide it? So here,
Well, he is a prisoner, and he gives quite a bit of detail about his grievance. He wanted to be moved, he wanted medical care, they didn't do it. Then he gets beaten up, and then he tells you exactly when he files the grievance.
I would actually
After
disagree.
that, he says, I filed an appeal, and they're destroying documents, they're losing them. What else can he say?
In regards to the allegation that they're destroying documents, I would actually argue that that's not something alleged in the affidavit. If you look at the affidavit, it simply says a response was not provided to, while it's not clear whether it was a response to the step 1 or a response to the step 2, but a response was not provided. And so
He adds, I believe this was done to prevent a successful lawsuit.
the response, Your Honor. And so simply not providing a response, it really has no consequence because as this court held in the Wilson decision, all that does is entitle the inmate to then proceed to the next step of the process. So the next step would be logically to file a lawsuit. You'll notice that...
You're saying there's nothing in paragraph 10 that says documents destroyed.
Absolutely. And so the...
Would that have been enough?
Possibly. I think it's a very hard question to answer without those facts in front of us. What I can say is that this conversation would probably look a lot differently if those had been alleged.
Authority, it says a sworn declaration, so the prisoner can be prosecuted for perjury, isn't sufficient for exhaustion from any published circuit authority for that simple proposition.
Not specific to the sworn declaration. However, it is well established that summary judgment affidavits still cannot be conclusory. So you can't simply provide an affidavit and say, well, it's sworn, therefore fact issue. That is not the standard. The standard is that the non-movement cannot satisfy their burden with conclusory assertions.
Let me ask you this. How does an inmate file a grievance? We're talking about filing a grievance.
Yes.
What does that mean?
So there are a
I
couple.
say, what does that mean? I know what filing means. How is that accomplished is a better way for me to ask the question. What do they have to do?
So if I understand your question correctly, what they need to do is obtain a grievance form, which can be found in the prison library. They can ask any official for the form. They fill out the form within 15 days of the complaint of accident. So here that date would be the March 20th, 2017 date. They then file it and put it in a grievance box, and then the prison will have 40 days to respond.
They file and put it in a grievance box. What do you mean? Is putting it in the grievance box considered filing it?
Yes. I think that's a bit of a term of art where, I mean, there's no electronic filing, anything like that. Simply putting it in the grievance box or even handing it to a prison official would be sufficient. So they have several different ways. But then more than
So
that.
if I wanted to be specific about what I did, I could say, I asked for a copy of a complaint form. I was given a copy of a complaint form on this date. I filled it out. And then on whatever date, I put it in it's a box?
Yes, a grievance box.
Put it in the grievance box and give a specific date about, and I guess different prisons, there may be more than one grievance box.
Certainly.
I
And
say which box I put it in, what date I put it in there.
I think in terms of the mechanics of physically, placing, handing it to an official, that's really not super relevant to the analysis because the key focus really needs to be on the timing. So I would agree with you that the inmate does need to specify at what time they filed the grievance, which here it is alleged it was done within 5 days or
What
so.
you're telling me is there's more than one way to file it. I could put it in a box, or I could hand it to
A prison official, anyone who works for the prison.
all right.
Yes.
Can we go back to this sort of hypothetical?
Sure.
Perhaps not hypothetical. Well, I'll just say hypothetical. A prison that is deliberately trying to mess with prison inmates by throwing away all the documents. I take it is your view that all that this prison inmate would need is to allege in a statement, sworn statement, I filed within X number of days, step one. I filed within Y number of days, step two. That would be enough then?
I think
To give the court comfort that we can look at a hypothetical corrupt prison.
definitely that would be closer to that, hypothetical goalpost because really the issue here is
If you're trying to imply that might not be enough, what would be enough?
so in terms
Or am I overreading you? Are you saying that would be enough?
I'm not sure if it would be enough. I think it would be a fact issue in regards to the specifics of the case.
But then what do we do with this hypothetical prison that is basically just trying to run roughshod over all inmates?
Well, I would note for the court that there is no allegation in the
Hypothetical.
sworn statement. And yes, in the hypothetical, yes, and I'm not sure if the court is familiar with the Barger decision, but to the extent it's helpful, the Barger case dealt with a prescription issue and whether a grievance was filed, and it really related to the timing and whether it would have told essentially the prescription period. However, there was an issue where the district court had looked at a conclusory affidavit or what they held to be conclusory, and they said, nope, this doesn't, create a fact issue. This court reversed and explained that the affidavit itself was sufficiently detailed. It was based on personal knowledge, and in regards to the destruction or the other reason behind why a prison might not have certain records, the inmate in that situation had described the defendant who had actually previously in his presence destroyed records. So the court said, well, there is an inference we can make that this is based on his personal knowledge. It's not speculative. So even engaging in any sort of hypothetical, you would have to have both specificity and then also probably some sort of documentary evidence.
But I'm confused. How are the prisoners going to get the documentary evidence? There are one of two things that could happen. In other words, this gentleman in his final sentence is not saying, I saw them destroy it. He's saying, I just never got any response. That's being honest. He doesn't know. He's in his cell. They're either sloppy and they lose some, must be lots of prisoners, or they actually really are. And he says in his final and swears under oath that he does think it's one of the two so as to be able to bar lawsuits. What else can a prisoner do?
Well, in regards to the fact that he says he didn't receive a response, again, I would just emphasize that really has no bearing on the prison's processes in terms of whether they're destroying grievances. There's really no correlation because by the affidavit's own allegations, the prison system should have a step 1 and then a step 2 appeal that he allegedly timely appealed. They do not have those pieces of evidence. They have nothing. And so to extrapolate from, well, I didn't receive a response, to because they have no documentary evidence, it's their fault, and really shifting the burden, it brings us back to the fact that at summary judgment, the TCJ defendants met their burden. The burden has shifted to appellant at this point. So yes, the onus is on the inmate in this situation to, at the very least, provide a sufficient amount of detail supported by facts because, as this court is aware, conclusory assertions are conclusory because there are no facts provided to support them.
Okay, but just to drill down that then, are you saying then, because I think you are saying this, a statement that said, I filed step 1 within X number of days, and that's timely, and I filed step 2 within a certain amount of days, and that also happens to be timely, that would be different from this case, and that would be enough.
Absolutely, but then we go into the substance of the grievance itself. So exhaustion.
Oh, sure, now you get to the merits, but the
Sure.
point is that would be enough to discharge, to create at least a fact issue as to exhaustion.
I would think most likely, but it's hard to tell because there isn't a lot of case law on it, and as this court just recognized earlier.
I'm just asking you, like, if we were to say that in this case,
Yeah,
that those two would be enough, you're not objecting, you're not arguing against that standard.
correct. So that really does bring us to the merits of the actual grievance. So there is absolutely no specificity regarding the actual claim. So here it's a failure to protect claim. In the affidavit, the statement is, I said my injuries were the fault of TCJ officials who were notified of the danger I was in. I'd like to break that down because TCJ officials is incredibly vague. TCJ could include anyone, but here there are defendants who are sued in their individual capacities, which is important because for a constitutional violation, you have to have personal involvement. Now, appellant does not state that Livingston, Collier, Haynes, and Alford were given any sort of notice. He wants the court to make that sort of logical leap, but he doesn't actually say that. And then if we move on to the next portion of his statement where he says they were notified. Well, when were they notified? What were they notified of? And you say they were notified of danger, but what danger? Because danger is in and of itself also conclusory. And so in this context, it needs to be viewed in light of the Prison Litigation Reform Act's intended purpose, which is to give prison officials time and opportunity to address prisoners' complaints internally. So this court in the Johnson decision stated that the amount of detail is going to depend really on the type of case. So, for example, in an inmate case where they're complaining about a policy, it might be sufficient to just complain about the policy. But in a situation where an inmate is complaining about an alleged bad actor, it will be necessary to identify the bad actor and provide as much detail around it because viewing it in the light of, well, does this give the prison notice of what I'm complaining about and give them the opportunity to investigate it? If TCJ were presented with a grievance that simply said, TCJ was notified of the danger I was in, how would they even begin to investigate that? They would say, well, how are we notified? Who was notified? When were we notified? None of that information is presented here. And so, by nature, it is conclusory, and the burden at no point is met by appellant to create a genuine issue of material fact. And I want to touch on, because he acknowledged the Dillon case earlier. Now, I'm surprised that he relied on the Dillon case, because the Dillon case actually says that because exhaustion is a threshold issue, the judge can resolve factual disputes regarding exhaustion, and even noted that perhaps holding an evidentiary hearing would be reasonable if needed. Here, his contention, as I understand it, is that it was completely inappropriate for the judge to not send this issue to a jury. But we don't even really get to that step of the analysis because he didn't meet his burden. There was no fact issue created So we are still operating under the assumption that TDCJ provided 200 pages of grievance records accompanied by a business records affidavit stating from January 2017 to December 2017, these are all the grievance records we have for this inmate, and these are the documents that we keep in the ordinary and regular course of business. Now, at that point, of course, the burden has shifted to appellant. So appellant really wants this court to adopt some sort of language where conclusory affidavits would be acceptable. But that's not only dangerous in just the inmate litigation context, but for all of summary judgment, because imagine a world in which a non-movement could provide no details and only provide unsubstantiated allegations, vague representations, and always be able to create a fact issue. That is not something that the Prison Litigation Reform Act obviously is intended to address, because by nature it is a statute that is not concerned with fairness or equitable grounds. Really, it is a procedural requirement that mandates exhaustion, and this circuit takes a strict approach to exhaustion, so there should be no reason why this court were to find that a conclusory affidavit such as here would be sufficient at summary judgment to create a fact issue. And specifically here, if inmates were allowed to do this, they would always be able to create a fact issue. And I do want to note for the court, and I think one of the judges brought this up, but appellant was represented by counsel, not only during the time where he would have been producing this affidavit, but also during this time where he was attacked and then would have been filing grievances. And so this concern that inmates are going to be disadvantaged, well, this isn't the typical inmate case. In fact, it should be a case where sufficient detail was provided, because an inmate has the benefit of counsel who allegedly knows the grievance procedures as well as the requirements of the Prison Litigation Reform Act, and would be able to counsel him that at summary judgment, we have to provide enough specificity to have this affidavit essentially serve as the functional equivalent of what is allegedly missing. That is not done here. So I see that my time is getting pretty close. Unless your honors have any other questions, I do think that this is a very simple case. It does absolutely turn on, is this affidavit conclusory or not conclusory? And I think your honors have rightfully noted that there are absolutely no facts when it comes to the timing and the substance. And when viewed holistically, this affidavit cannot serve as the functional equivalent of the grievances that he allegedly filed. So for that reason, the district court's grant of summary judgment should be affirmed. Thank you.
Thank you, counsel. Rebuttal.
I'll wait for the timer. May it please the court. I'll start at the end. Opposing counsel basically suggested that the standard for this kind of statement is that the inmate basically recreate the grievance in hyper-specific detail such that it's the functional equivalent of what's missing. Notably, there is no citation in a case law that states that it has to be the functional equivalent of what's missing. That standard, to appellant's knowledge, is not the standard that needs to be met, but that there's a sufficiently specific factual allegation that a reasonable fact finder could use to find in favor of the non-movement. And in this case, what we have is, as we went over in detail, a highly specific statement that goes over the details of the attack and what happened in the timing of the filing of the grievance. And as opposing counsel mentioned, there's 15 days between the result of the grievance and the appeal that has to pass, and that the appeal was filed within that 15 days.
Suppose a action in federal diversity jurisdiction.
Okay.
All right, and then there's a motion to dismiss for lack of subject matter jurisdiction, and the response is an affidavit that says, I'm diverse. Would that be enough? I come from a different state from the other party.
It would not be enough, and this is why, and it actually...
And you see why I'm asking. That seems pretty formalistic too, right? What's the difference between saying I'm from a different state versus I'm from Texas and you're from New York? That's a pretty formalistic distinction, and yet one that you would agree we would have to enforce. Why not here?
Right, and the distinction between that affidavit and this affidavit is exactly the crux of the issue, and that's this. The injustice here is that the inmate has no control over what documentation is going to be provided by the prison. The prison and their ability to keep records accurately is
What does
outside.
that have to do with his ability to put forth a declaration?
It has to do, so,
I'm giving you all that. I'm giving you
Right.
the Palladino standard, but you got to say something. You
right,
can't
so,
just say you're diverse. You can't just say you're
Right.
lively. You have to tell me a story.
exactly, so in the diversity case, you have to show that you are.
I live in Texas. You're from New York. Right.
Exactly, and you have control over what evidence you can provide. Because you're domiciled in a place, you can show, you have evidence that
Right,
you
fair enough,
can show that you were domiciled.
I'm not talking about documentary evidence. Palladino says you don't need documentary evidence. A single unsworn, I think the quote is, a single unsworn affidavit or sworn affidavit would be enough. Presupposing we embrace that standard, you still need to have an affidavit that provides those facts, right?
Right.
I'm just reading from Palladino, a single non-conclusory affidavit or witness testimony, when based on personal knowledge and directed at a material issue, is sufficient to meet summary judgment on exhaustion. So accepting that standard, you don't need documentary evidence,
Right.
but you do need to have these specific facts.
So, I suppose then, I guess I just need a little bit of clarification on the question. I guess how is the diversity question relevant? Just in terms of,
Well, if you agree that you can't just utter the words, I satisfy the statute, I am diverse, you have to actually explain
right,
that you come from a different state from the other party and therefore satisfy federal subject jurisdiction, subject matter jurisdiction. Same here. You can't just say that you've been timely. You have to actually tell me you filed within X number of days and are therefore timely. It's formalistic in both cases. It's just a few words in both cases. But if it's important in one, it should be important in the other. Or I think you got to tell me
I was about to say, I'm not sure that it's necessarily important in both in the same ways. But also the distinction there is, saying I'm diverse is so broad as to not mean anything, but saying I filed a timely appeal is saying that I filed an appeal within 15 days. That's a far more specific statement than saying
I'm diverse. Obviously, you know what I mean by diverse. I come from a different state from the other party. Everybody, that's 1L Civ Pro.
I guess my response is twofold. First, that there's a difference in specificity between I filed a specific piece of paper within 15 days in response to another specific piece of paper, and saying, well, I come from one of the other 49 states, but not this one. Those are two qualitatively very different things. First of all, and the second response to that is because the issue is inherently different in terms of the control over ancillary or documentary or other evidence, that the formalism becomes overly burdensome to the point of injustice in this case, but it doesn't have the same risk in a diversity case. Thank you.
Thank you, counsel. The court will take this